Thank you all for coming to join us today. I'm just reminding you that next week is Fairleigh Dickinson spring break, so you are welcome to come here, but you may find the doors shut, and you certainly will not find any speakers. It's a lovely building to look at from the outside, and you may choose to do that. But we will take a break in our session next week, and we will be back the following week for a discussion by Bruce Barron on the media and law. Today we'll talk about the wonderful effects of the wonderful opportunities that journalism presents and how we ought to defend the authority and privileges of journalists. I think Mr. Barron may take a slightly different tack, but because of that we'll have a healthful tension and discussion, I hope, from these 2 weeks. But those 2 weeks will be divided by our spring break. It is something of a cliche in talking about children to note that for most 4-year-olds, the world looks like a nail, assuming they have a hammer. And as the parent of 2 young children and the owner of a fairly well-dented car, I can attest to the reality behind that statement. But as a kind of metaphor for the world of ideas, this notion that if you have a hammer, the rest of the world looks a certain way, that idea can be pretty useful. And what I mean is something that I hope every student and every citizen experiences at some point, every educated person experiences at some point, and that is if you have an idea, something you're worried about, whether it's a paper to write or a new philosophical principle, a paradigm that you've gotten your head around, the rest of the world can be funneled through that in revealing and interesting and often limiting ways, but in ways that make you see the rest of the universe and the rest of the events around you differently. And to me, that's been occurring over this past week in thinking about today's speaker, Ms. Lucy Dalglish, and our topic of the Shield Law and journalism and this intersection of law and journalism in the 21st century. Over the past few days, there have been a number of stories in the paper and on blogs on a number of different issues that relate very broadly to this idea of the intersection of law and politics. And one of them relates to apparently a advertising campaign run in the Los Angeles Times. This is, of course, a New York Times piece that gleefully put down one of its competitors. The basic gist of it, for those of you who are beyond the first 2 rows, is that this advertisement, which is for the new Alice in Wonderland, has a backdrop which is the front page of the Los Angeles Times. It becomes increasingly difficult in this depiction to separate what is news and what is advertisement. Some of the text of this advertisement are in fact the actual copy from the front page of the Los Angeles Times. Another example is a story that ran recently suggesting that the National Enquirer, yes, that same bastion of journalistic integrity that has often depicted various celebrities as having alien love children. The National Enquirer, according to this story, is getting increasing amounts of respect for its reporting, in part for its coverage of the John Edwards scandal. That's interesting to me. That suggests that we have clear sense of what strong journalistic standards are, and our minds are perhaps becoming more open to where that reporting can come from. The point is, my mind has been open to some of these issues, and as a result, I've been looking for these stories, and in part that's because of today's topic and today's speaker, whom I think will be a terrific person to guide us through some of these issues, and certainly to talk about the heart of our conversation, which is this notion of the federal shield law and what it's for, what its merits might be, and where we stand with respect to this legislation and this policy. So our speaker is Ms. Lucy Dalglish, the Executive Director of the Reporters Committee for Freedom of the Press. And Ms. Dalglish will talk to us a little bit about what the Reporters Committee does, some of its work, and she will talk to you about the Shield Law. I will simply introduce her by noting that she has a Bachelor of Arts in Journalism and had a career in journalism as a reporter prior to becoming a lawyer. She got her law degree from Vanderbilt University School of Law, but was a reporter in Minneapolis for over a dozen years. After that time, she worked in a law firm, the firm of Dorsey and Whitney in Minnesota, before coming to her present post, where she is the Executive Director at the Reporters Committee. So please join me in welcoming Ms. Lucy Dalglish.
Thank you. Welcome on this beautiful, beautiful day. I'm flattered that so many of you came when you could be outside doing something fun. And what a wonderful idea to have a session like this, combining people from the community and students. It's really a wonderful idea to have a session like this. You're to be congratulated for scheduling something like this routinely throughout the semester. As Bruce said, I am the Executive Director of the Reporters Committee for Freedom of the Press. We are an organization that is celebrating its 40th anniversary this month. It is an organization that was founded by a group of New York and Washington reporters in 1970, at a time when the administration of Richard Nixon was aggressively seeking the identities of sources and observed information from reporters all over the country. They were reporting on stories such as the Vietnam War, drug trafficking, stories about the Black Panthers. I don't mean to suggest that Nixon was the only one involved in any of this. In fact, the last 18 months of the Johnson administration and the first 6 months of the Nixon administration, NBC and CBS news networks alone had received about 500 subpoenas for information that they'd gathered while covering stories. But in 1970, these reporters got together at the Georgetown Law School library and said, enough is enough. There was a particular story that they were very distressed about, and it involved the very first African-American reporter for the national desk of the New York Times. His name was Earl Caldwell. And he was working out of Oakland, California. He had covered a story about the Black Panthers. He had developed their trust. He was just coming up with breaking news story after breaking news story. The feds wanted to know who his sources were, what he had seen. He was working for the New York Times, and in those days, unlike today, if your news organization if you were subpoenaed, your news organization might just say, oh, what's the big deal? Just go talk to them. Well, reporters, for more than probably 80 to 100 years before that, one of the most important credos in journalism ethics, right next to report the truth fully and accurately, and don't plagiarize, is act independently. And if you make a promise to someone, keep that promise. So the New York Times basically was letting Caldwell float. They just said, you know, what's the big deal? Just go testify to this grand jury. And these reporters, and they were folks such as Mike Wallace, Jack Nelson from the Los Angeles Times, Tony Lucas from the New York Times, Eileen Shanahan from the New York Times, Ben Bradley from the Washington Post, Fred Graham, who is still on our steering committee. They got together and they said, you know, we need to come up with a reporters committee to help reporters. And back in those days, reporters thought that they had a First Amendment-based right to protect confidential sources and information. They had just always assumed, and why wouldn't they assume it? I mean, in the 1960s, there were several cases, the most important of them, New York Times versus Sullivan, in the libel realm, where the United States Supreme Court had given quite a bit of First Amendment protection to journalists, and they just thought, well, the First Amendment is going to cover this as well. Well, the Caldwell case was thrown in with two other cases from Rhode Island and Kentucky, also surrounding this issue of whether or not these reporters would have to testify to a grand jury. The United States Supreme Court heard argument, and in 1972, in a split decision, what they call a plurality, they decided 4-1-4 that there was no First Amendment-based protection for reporters to protect confidential sources when they were being compelled to testify before a criminal grand jury. 4 justices said clearly no privilege. 4 justices said absolutely there's a privilege, and there was 1 justice down the middle, Lewis Powell, who said, well, I could see it sometimes, but not in this case. So Brandsburg went against these reporters. Now, the Supreme Court also said, you know, we're not going to find a First Amendment-based constitutional privilege for you. But if states and the Congress want to pass statutes conveying that privilege, that's fine with us. After all, the state of Maryland had passed the very first shield law back in the 1890s, and it had worked very, very well. And the Supreme Court said, you can pass a law like that on the federal or the state level if you want to. We're not going to give you a constitutional privilege. Now, reporters believed that they had a First Amendment right based on three basic arguments. I call them the burden argument, the independence argument, and the truth argument. The independence argument goes like this. You have greater chance of being trusted and a greater chance of being given information by sources who have reason to fear turning that information over if you are viewed as acting independently and not as an arm or an agent of some prosecutor or an agent of a criminal defense attorney, or on the civil side, an agent of one of the litigants. In other words, the public will believe and perceive that you are operating independently if you cannot be compelled willy-nilly to testify anytime somebody in court wants you to come in and testify. Then there's the truth argument. The truth argument is basically this. If people feel comfortable giving valuable information to reporters and giving it to them sometimes, on occasion, under a promise of confidentiality, then citizens have a greater chance of the truth ultimately coming forward. And after all, what is a democracy? A democracy is citizens getting together, taking the information they get, usually from the media, and using that information to make informed decisions at the ballot box. And on occasion, if you can promise someone that you will not reveal their identity to a court, you have a greater chance of that truthful information coming out. That's the classic whistleblower scenario. And thirdly, there's the burden argument. I know from working in states all over the country that if you make it too easy for prosecutors and litigants to subpoena reporters, they find themselves the most frequently subpoenaed people in any courthouse. That can be for their outtakes, for their notes, you name it. And particularly if they are a young, attractive, articulate television reporter. You can spend enormous amounts of money if you are a newsroom manager complying with these subpoenas. So we believe that it's necessary to turn reporters from being the most frequently subpoenaed people in a courthouse to being the last people you subpoena, the witness of absolute last resort. Now, over the last, well, since 1972, 38 years, we have seen state after state after state pass shield laws. Today we have 37 states and the District of Columbia that have statutory protection or a court rule, such as they have in Utah, saying that reporters do not have to testify. Some of the states have absolute privileges, and that is that they don't have to testify under any circumstance. Most of them have what we call a qualified privilege, and that basically is that the reporter is the source of last resort. There's the other states, all except one, have some form of what we call common law protection. That is, a judge has recognized that under some circumstances it's necessary to extend that protection. The only state where we don't really have a clue what kind of protection there is Wyoming. Apparently no one's ever tried to subpoena a reporter in Wyoming, so they don't need a statute, they don't need common law or whatever. It's just never been an issue there. The federal government has been a completely different story. Between 1973 and 1978, there were 99 separate bills introduced in the United States Congress that would have provided some form of federal shield law. Now, those of you who are lawyers or have worked in the legal area know that in this country we have a dual system. If you are subpoenaed in a state court trial, you have to rely basically on state reporter's privilege law. If you are subpoenaed to testify before a federal proceeding, you have to rely on federal law. Now, for a reporter, reporters don't really care when they're going out and covering a story. When they go out and cover a bank robbery or a murder or any one of a number of different types of stories that could conceivably end up in court, they're not going out there going, all right, I might have to interview a source. Can I promise them confidentiality? Well, let me see. Do I think this case is ultimately going to end up in state or federal court? Reporters just don't think that way. Yet that is the bind that many of them find themselves in. As I said, we tried in the 70s to get a SHIELD law passed. In the 80s and 90s, nothing had ever passed on the federal level. In the 80s and 90s, there had developed a series of cases that had left us with some pretty good protection for reporters in the federal side. It was always going to be almost impossible to avoid testifying in front of a federal grand jury. But courts around the country had found a basic level of constitutional protection in civil cases and in kind of generic trial testimony on the criminal side. We had developed a body of law over those years based essentially on Justice Powell's concurrence, where we were able to convince courts that because Justice Powell said, well, I could see that there might be a situation where we could protect people, we were able to convince many courts that that was so. Well, the perfect storm that essentially brought down the federal reporter's privilege happened in about 2003, 2004. There was a case in Chicago where some reporters for the Sun-Times and the Tribune were working on a book about terrorism in Ireland. This was not in their capacity as newspaper reporters. They were working on a book. They were asked for a copy of their audio tapes of an interview that they had done of a witness in an Irish terrorism case. The prosecutors in Ireland wanted a court in Chicago to compel these reporters to turn over the tape. The reporters were ordered to turn over their tape. They resisted. They tried to go to the Seventh Circuit for a stay. The Seventh Circuit denied this stay, and they said, well, you know what, we don't want to risk really bad law being made in this circuit, so we're just going to drop it. But there's a very influential Seventh Circuit judge by the name of Richard Posner. He thought this was a really, really interesting case. So he didn't have anything in front of him at all. There was no briefing. There were no oral arguments. He just wrote an opinion. He didn't have anything in front of him. And he said, you know, this is a really interesting case. And I just reread the 1972 Brandsburg case. And you know what? Anybody who thinks that case provided any sort of a privilege is really, I think he used the term, skating on thin ice. And starting in 2004, the reporter's privilege just started to collapse. Well, what was going on back in those days? The Bush administration was working a lot more aggressively on national security cases, in other regular criminal cases, and they were starting for the first time in 35 years, aggressively subpoenaing reporters to testify in court, and it coincided with this Posner decision. And all of a sudden, we found ourselves, as an industry, spending enormous amounts of money and incredible amounts of time fighting off these subpoenas. We've had quite a bit of success, actually, but I predicted back in 2004 that it was going to take 4 to 6 years to get a federal SHIELD law passed, and I think I've actually overblown my, I think it's going to take probably closer to 6 or 8 years. But over the last 4 sessions of Congress, we have gotten SHIELD laws introduced, and we are slowly coming closer and closer to getting a federal SHIELD law passed. The United States House last spring passed on a voice vote a very good bill that provides broad protection for journalists, but to a very, very narrow group of journalists. In other words, you have to prove that you are a journalist by demonstrating that you are earning income, that some of your livelihood is based on this. Your livelihood is based on your being a professional journalist. On the Senate side, we have a much narrower scope of coverage. It only covers information that was passed on by a confidential source. In other words, you have agreed to protect the identity of the source or any other information that might identify your source. But the Senate has a broader definition so far of who is covered. You don't have to demonstrate that you have earned a living by being a journalist. Now, in this day and age, you're probably thinking, obviously, who's a journalist? Are you going to let one of those damn bloggers be covered? Well, you know, there are plenty of bloggers out there who are doing journalism, and there are plenty of bloggers out there who are not. So the trick is really trying to come up with a definition of who is covered that looks at the function being performed by the journalist. In other words, if they are committing journalism, not just aggregating a bunch of stuff and throwing it out there for people, but if they are collecting information, doing something to it editorially with the intention all along of disseminating it to an audience, then they are going to meet what we call the von Bulow Standard. That's a Second Circuit decision where they decided, and in cases when you meet the von Bulow Standard, it has been used to find that some people are journalists and some people are not journalists. And those of you who are no longer in your teens are recognizing the name of this case. This was a situation, the civil case, involving the notorious Klaus von Bulow. He had a woman that he was close to who was subpoenaed to testify in his case and in his civil case, and she said, "I don't have to testify, I'm a journalist." Well, it turns out what the court looked at was, at the time you had these conversations with these people, in no way did you represent to them that you were a journalist. She said, I don't have to do this, I'm writing a book about my experience involved in this case. And the court said, at the time you talked to these people, you had no intention of writing a book. You didn't tell them you were writing a book. Let's get serious, you're not a journalist. And she was compelled to testify. That test has worked very, very well over the years, all across the country, in determining whether or not somebody is actually out there doing journalism. We are, as I said, in very good shape on the House side. If a bill passes, I'm predicting it's going to look very, very similar to the Senate bill. The Senate bill, as I mentioned, only covers maybe 15% of all subpoenas served on America's journalists. Those are the subpoenas that ask for confidential source information. Most of the subpoenas reporters get are actually asking for eyewitness testimony. They are asking for transcripts of jailhouse interviews. They are asking you to confirm a conversation you had with somebody that you may have written about or produced a story about. So the Senate bill is a very, very narrow definition. It has gone through the Senate Judiciary Committee, and we are in the process of waiting for a vote. I mentioned the fact that one of the big problems with the bill, or one of the challenges with the bill, is deciding who would be covered. The other challenge that we've run into on the federal side that you don't normally worry about on the state side is, what do you do about national security? Basically, the way both of these bills are written, if any prosecutor or anyone else walks into court, stands up and says, Your Honor, national security is implicated, that person is going to win, and the reporter is going to be forced to testify. All you have to do really is burp out the words national security, and there will not be a privilege. Fortunately, not that many of these subpoenas are seeking national security related information, so I think it is still a very valuable bill. It will be a qualified privilege. That means that it will not be provide absolute protection in all circumstances. Rather, the person seeking the information will have to go to court, and demonstrate to a judge that they absolutely have to have this information to make a successful case, that it is going to ultimately be found to be relevant and admissible in court, and that there's no other way to get it other than from the reporter. In other words, that the reporter is the source of last resort, not the source of first resort. There also will be a public interest balancing test. So let's say the person seeking the information is able to demonstrate those other three things. They will then have to, the media or the reporter will then have the opportunity to convince a judge that all things being equal, the scale tips more toward the public's need to get the information versus the litigant's need to get the case, get the information for their case. It is important to acknowledge that every journalist I know of who is arguing in favor of this privilege recognizes that it is a privilege. They are asking for something that ordinary citizens don't get. Most of them, when they're talking about this case, are asking for this privilege with humility because they understand that for a society such as ours to function, you have to be able to assure that people can be compelled to court to testify and give information. But just as priests and there's a privilege between a priest and a penitent, a privilege between a doctor and a patient, a privilege between an attorney and a client, there are certain people in society that we have agreed to grant privileges to against having to testify because we believe that there is a value in encouraging people to come forward with information and sharing it with other people. And journalists basically are asking to be recognized as someone who on occasion can take advantage of that privilege. I can also say with that in the 37 states and the District of Columbia, which have been granting this privilege for, well, in the case of Maryland, 120 years, the justice system in those states has not crumbled. These laws work very, very well. I think I'm very encouraged. Right now we are working with Senator Durbin on perfecting the definition of who would be covered. Everybody up on the Hill is fairly satisfied. We even got the White House and the intelligence chiefs to sign off on the exception for national security information. But now we're just trying to tweak who is going to be covered by this privilege. And with that, I would be happy to answer any questions that you might have, talk a little bit about the Reporters Committee, or anything else related to the area of media law that you might find to be interesting. And Bruce, you have a microphone back there? Okay.
Yes. My question is this, and I don't know where this comes from, but let's say I'm a reporter and I've done all this research and I know that this person's going to get called into court and prosecuted, and I have the privilege, so I'm okay. And then whoever it is dies. Now, my question is, what happens at that point? Can the court require my sources, or can I then argue further that the stuff that I've done is going to harm other people and I need to retain the privilege?
Well, in shield laws in the states that have them, the privilege does not belong to the source, it belongs to the reporter. So you are going to have that ability. I am familiar with one case where a reporter had a conversation with a source. It was somebody who was serving time, and she went to interview him in prison. She was working on a book, and while she was working on this book and before his brother was being tried, he died. And she looked at the law in her jurisdiction and made the determination after, the prosecutor coming and kind of shaking her down a little bit. There was no other source. she was going to. So she made the voluntary decision to disclose that particular interview information and nothing else. And would she have had to? In some places, maybe. In other places, probably not. But she made that determination. They knew who the source was. Ordinarily, they could, go to the source, but she made the decision that he was dead and that there was no other way this information was going to come forward. So she did testify. That's really the only time I can think of off the top of my head where that has happened.
Just one follow-up. Does the reporter then get to decide which of this bunch of information they testify on, or is it included in the subpoena? How does...
Typically, what happens when you get a subpoena, they will give it to you and say, we need you to come and testify about X, Y, and Z, and by the way, bring these 3 or 4 things with you. Your notes, your outtakes, any material you gathered, and whatnot. But once you're there, you have no control. If it's a grand jury situation in particular, you don't get to go in there with a lawyer. They can pretty much ask you whatever they want. On occasion, I have a lot of friends who negotiate and say, there are some reporters who will say, okay, this privilege in my state, or certainly on the federal level, is virtually non-existent. We will testify, and they will try to get an agreement from the prosecutor. We will provide the foundation for the information that we published. And we will answer questions. Yes, I interviewed Mr. So-and-so. Yes, this quote in the newspaper, yes, he told me that. And you limit that scope, and that gets around the prosecutor's hearsay problem. But typically, you can negotiate that all you want and get a prosecutor to make a promise like that, but once they've got your reporter up on the stand, and then the defense gets to try to impeach you, and then everything's out of control.
First of all, thank you for a very cogent presentation. It was well done. Good history. My question to you is this. As an organization trying to get the SHIELD law, the federal SHIELD law passed, do you lobby directly as an organization? Are you retaining lobbyists? Who are your supporters principally in the Congress? And who are those who are steadfastly against this legislation?
We do not directly lobby. I mean, I'm not in charge of a lobbying organization. We belong to a coalition that is organized by the Newspaper Association of America, which is a trade association. They and the National Association of Broadcasters essentially have been paying for the paid lobbyists to go up there on the Hill. On occasion, I am invited to go up there and provide background information, and I do that. Or I'm invited to come up and brief a Senate staffer on that, and I do that. We're a 501c3. We're not really a lobbying organization. We get our money from media companies, individuals, non-media corporations, a lot of foundations that were built with rich media family money, such as McCormick and the Knight Foundation. So we're very involved in this, and obviously this is an issue that is near and dear to my organization's heart. Your question, the biggest supporters on the House side, this is a bipartisan bill. The House sponsors are Democratic Representative Rick Boucher from Virginia and Republican Congressman Mike Pence of Indiana. They have done a marvelous bipartisan job getting broad-based support. I mean, in the House side, this thing last time passed on a voice vote. There's very, very little opposition on the House side. On the Senate side, the sponsors have been Senators Lugar, who's a Republican, Dodd, who's a Democrat, Specter, who was a Republican and is now a Democrat, Senator Lindsey Graham, who's a Republican, Chuck Schumer, Patrick Leahy, and I might be missing one. We have many, many co-sponsors, but they are the leaders. Senator Lugar was actually the first one to really come out and say, Lugar and Specter were the first ones to really, really push this on the Senate side. Our biggest opposition is coming from one guy. His name is Jon Kyl from Arizona. He has put secret holds on this thing several times, but it's really easy to figure out, you know, it's like there's no secrets up there, right? He's done everything he can. In the previous administration, he was basically on call from the Justice Department. The Justice Department now is in favor of this bill. We negotiated long and hard on it. We managed to come up with compromise language, but Senator Kyl still hates it. What has happened, I'll tell you what really blocked this thing this time. Well, all of a sudden we have a bill done in the House. We've got a White House that loves this bill. We were doing just great in the Senate, but Senator Specter was the ranking member of the House Judiciary Committee. He was replaced by Jeff Sessions, who hates this bill. And a lot of the Republicans, other than Lindsey Graham and Senator Grassley and Senator Hatch, are in favor of this bill. The rest of them are so ticked off at Specter that they're doing everything they can just to teach him a lesson. So we've gone from having an almost sure bet. If you ask these guys on principle, do they have a problem with it, they'll tell you no, they just don't want to, you know, let Specter win. It's really frustrating, really, really frustrating. But we're going to event. If we can get Senator Durbin satisfied, those of you who are, you know, watch the Senate, Durbin is like second in command to Senator Reid. If we can get Senator Durbin satisfied, because he's fairly high ranking in the Senate Judiciary Committee, then he will go to Reid and say, okay, now you can put it to a vote. And then we'll get a bill. That's what's going on.
Lucy, I have a question for you. I wonder if you can talk just a little bit more about the definitional issues, which you've certainly touched on, but I take it are behind some of the opposition to the Shield Law. And I mean, in thinking about it, we might compare it to physicians, right, where there's not particularly a great amount of controversy about what constitutes a physician, whom we would exclude, whom we wouldn't trust. I'm sometimes called doctor, and I shake my head because I have a PhD, but I don't actually help people, whereas my wife, who is a physician, does regularly assist people. But for journalism, I wonder if it's a little different, or if it could be perceived as different in the sense that one of the standards is helping democracy, is being able to educate citizens, and news organizations themselves will often turn to citizen journalists and say, well, we need your pictures, we need your stories. Right. That's one point. The other obvious point is the historical traditions of relatively unprofessional, independent journalists writing critiques of government. And I suppose the inevitable other observation involves changing technology and the increasing access of a kind of electronic printing press. So I wonder if you could just talk a little bit more about those concerns, how much of them trouble you, and the degree to which you're not troubled, and why.
Well, I've never been all that troubled by partisan press. You know, we have a rich history in this country of having an unfettered, partisan, opinionated press. So, you know, it's actually only in the last 100 years where we actually tried to reach some form of, some people would say fairness, other people would say balance, some people would say objectivity. So that's kind of a new thing for us. In many ways, we're actually going back to our nation's roots, where you have all of these different voices sort of in there beating each other up, with the notion that as long as you do that, the truth will eventually come out. You're right, journalists in this country are not licensed, and that's a really good thing. You don't have government deciding who's qualified to take information, do something to it, and disseminate it to an audience. I think what we are going to end up with on the Senate bill is some sort of a, well, Senators Feinstein and Durbin call it a professionalism test. To me, that means somebody got paid, but I think what they're saying is, do they have a track record? In other words, was this the first time they ever went to a meeting or first time they ever talked to anybody and did something and disseminated it via their computer? No, what they're looking for is some kind of, I don't know, a numbers test. 6 times in the last 2 years, you did something out there. You committed journalism. You know, you gathered information, did something to it editorially, not just aggregated it from other sources. You talked to people, you gathered information, you did something original I think original is a good word to put, and then you disseminated it to an audience. Now, keep in mind, all this that's been going on, even the 2 or 3 journalists in the last 5 years who could be called bloggers were people who were doing it either for a living or who had done it every single day. For the most part, these subpoenas are going to folks with enormous credibility, enormous skill, an enormous track record of having provided valuable documented information. Because look, you don't want to just, those of you who are lawyers know, you don't want to just go get some nut off the street. What good is that going to do you if you're trying to put on a case? You're trying to find somebody with credibility, which always, having been a journalist for so long, and then I was a trial lawyer doing media law for about 5 years, and now I've been doing this job for about 10 years. There's this notion out there when you talk to lawmakers and other prosecutors, yeah, but these are great witnesses. No, they're not. They're terrible. If you put a reporter on the witness stand, they're just the worst witnesses you've ever seen in your life. Because what they notice and what they remember has absolutely nothing to do most of the time with what a prosecutor or a litigator wants to know. And they're always up there trying to help you, saying, well, no, you got your whole case wrong. Let me tell you what really happened. They're terrible. They make rotten witnesses. They really do.
So Matt Drudge, for example, is a home run, clear-cut case of a journalist, right? He's created stories that are independent.
If he's done something independent and he's gathered information and done something to it, sure, he can be considered a journalist. You bet.
The person that's being interviewed, can that person claim that they want confidentiality for any reason? For example, let's say they didn't want to speak because they were a member of a party and their career would be,
sure.
Would that be accepted? But
Sure.
if they just argued, well, I don't want my name known in this, would that be a sufficient?
I think legally, I think it would be, but I can tell you one thing that's happened over the last 10 years, and I've been working with a lot of newsroom managers. We know that the media took an incredible hit 4 or 5 years ago, in the Wen Ho Lee and Valerie Plame cases. And we know that the public has no appetite for confidential sources whatsoever. So we also know now that you really only have credibility if you use confidential sources in the rarest of occasions. So most newsrooms that I've gone to and talked to folks, they've implemented new guidelines that you have to get permission from an editor. Now, granted, this is if you're working for somebody, but you have to tell a supervisor who your source is, and you really oftentimes will have to go back and ask for permission to grant confidentiality to that source. I think USA Today, when Ken Paulson was editor, determined that in the space of 1 year, he had reduced the number of confidential sources used in USA Today by 80% in just between 2005 and 2006. He said there were some stories, they did not lose them altogether, but there was some richness in the stories. There was some background information that would have been very useful. But they decided, because it was coming from folks who wanted to be anonymous, and that they could tell the story, it wouldn't have been as good a story or as complete, but they could still tell it. And I think newsroom managers around the country are telling you that the use of confidential sources has actually declined. You're also probably, if you're a newspaper-based reader, you've probably also noticed that they're telling you, when they grant confidentiality, they're telling you why more often. In other words, so-and-so who was promised confidentiality because he was not authorized to speak or was worried about reprisals or whatever. I think most mainstream news organizations are giving you a better idea of why they're granting confidentiality than they have in the past.
We have another question here.
The Judy Miller, she asked whether or not the Judith Miller case was ever settled. Yes, What happened was, after 85 days in jail, Judy had been subpoenaed. She never did do a story. She had gone out and had lunch with, apparently it turned out to be Scooter Libby, for a series of stories she was writing on chemical and biological warfare. And during this lunch, he apparently said to her, oh, by the way, just so you know, there's this former ambassador whose wife is working at the CIA. And she goes, that's not really my thing. I'll just, she writes it down. She goes back to the newsroom. She claims she told Jill Abramson, the bureau chief, about all of this. Jill says that didn't really happen. Who knows? But she never wrote a story about this whole thing. But they found out, I think what happened was they went to the White House, looked at phone logs, looked at all the reporters that certain people like Karl Rove and Scooter Libby had talked to, went back and then served subpoenas on all the reporters saying who told you what when. Judy says that she had not gotten a official, personal permission from her source to reveal his name. So she goes to jail for 85 days. Eventually, they connect in some way. He gives her permission to testify. She comes out, she testifies, then he is on trial. She testified before the grand jury. Was either that or she was deposed by Patrick Fitzgerald, I can't remember for sure. And then she did end up testifying at the trial. Of course, then he was convicted, then his sentence was commuted. So that case is over. That was a nasty situation. Involved games being played by, what people forget is that there were actually about 15 subpoenas served in that case on reporters all over the place. And they all had different ways of handling it. She's the one, though, who actually went to jail.
We have another question here.
Based off of the Ireland case that you mentioned previously, how would the passing of SHIELD laws impact international law and relations?
In that particular, impact, I'm sorry, I missed the last part.
International law and relations.
Well, it would make it very difficult for an Irish court or any other court to come over here and ask for a subpoena to be enforced against an American reporter. If what they were seeking under the Senate bill, you would be able to be protected if what they were seeking was confidential source information. Under the Senate version of the bill, I'm not sure there would be any protection for the reporter here because it wasn't a confidential source. They knew who the source was. It was an audio recording of an interview with that source. So I think under the Senate bill, they would be able to get the tape. Under the House bill, they would not.
I mean, in part, it sounds like the bill that you're supporting, or at least the general SHIELD law initiative that you're supporting, is small d democratic, right? It would seek to at least expand protections away from paid journalists, or what are sometimes called institutional journalists, right? Anybody who, in theory, anybody who is creating work with journalistic credibility that is independently researched and adds value could fall under this protection. So the question is about other kinds of protections that the institutional press has enjoyed and what you make of those, whether those should also be democratized. In other words, to take an area close to my interests, the Supreme Court, right? The Supreme Court chamber is fairly small, but it has seats set aside, it has credentials set aside, both the so-called day passes, the day credentials, as well as the hard credentials they give to regular folks who appear before the court. To what degree should we be trying to push to have those credentialing procedures? They're not quite licenses, but they are achieving some of the effects of licenses. To what degree should we be pushing to make those kinds of forms of access more democratic?
Mayor Bloomberg announced that to get a New York City press pass, what did they tell me? You're going to have to demonstrate that over the past year you published 6 times in something relatively mainstream. In other words, it wasn't just your own proprietary blog that you just sort of pop out there. Now keep in mind, these are not rights. You don't have a right to get that close to a politician. What they've decided, when you have a credential, it means you have been screened, you have volunteered to submit your information, your social security number, all of your vetting material. They do a public safety check on you. You are asking for slightly better access than anybody else on the street. And you do have to go through a vetting process for all of that. You submit them all sorts of documents. I don't have a problem whatsoever with those credentials being extended to anybody who's out there doing journalism. I view this whole thing over bloggers, I view this as just another technology. It's sort of like, who is it, Potter Stewart said about obscenity, I know it when I see it. When it comes to journalism, I kind of know it when I see it. And there are, I got a phone call from, what state was it? It was Friday afternoon. There was a fellow, Maryland. There was a fellow who is a full-time lawyer, but he has his own website. And he wanted a state Capitol Press Corps credential, and he wanted some certain level of access so that he could travel with the governor. And the governor's office said, you know, we have a limited number of these. We can't take that many people. This isn't your real day job. There are other people here. You've got this blog, and we don't think you're actually out there doing journalism. We think you're providing some value, but and he's filed a lawsuit. And he's saying that his civil rights are being violated because he's not being given this credential. And I was like, I just don't know what the cause of action would be there. Because it's not like you have a right to get that close to a governor. I mean, any public official has the right to come up with reasonable time, place, and manner restrictions that gives, you know, the public some access, but also gives you the right to operate safely and efficiently. So I don't anticipate that this lawsuit is going to really go anywhere. But there certainly are some internet-based journalists who have been given these credentials. There are a number of them. They've kind of banded together covering prominent high-profile court cases. And there's something, I think if I were a routine, regular blogger who was covering the news, I would join the Online News Association. I'd have my little membership card, and I would say, hey, you know, I've covered these 3 trials for this particular website. And I think in that situation, I know Judge Hogan down in Washington recognized them as part of the press pool for the Scooter-Libby trial.
Just to follow up, I guess part of what I'm wondering about and it's troubling me is it comes from the kind of supply end. That is, if you're somebody with information, you want to give it to a quote-unquote reporter, and you want to be sure that you are unlikely to be, your identity is unlikely to be divulged. You want to be a whistleblower. Are we still clear on who will be granting that protection and not? I mean, you say that you know a journalist when you see one, but does the source?
Well, it's a really good question. That's why I think at this stage you're not seeing that many anonymous sources being used by internet-based journalists, because sources also want to know that you're going to be able to give them something. You're going to be able to stand up and provide them with a certain level of protection. So if I were a source and I wanted to turn information over, I would go out and seek somebody who either has a reputation individually for having done that, like a book author who has a track record, or someone who works for a news organization that I know has stood up for this principle in the past. That's absolutely something I'd be looking for.
Let this be a warning to the students in my class who are going to be whistleblowers on the abuse and corruption in my classroom. Any other questions? Hold on one sec. Here you go.
This is from a different angle. Have you ever run across a scenario where an investigative reporter gets into like a cell or something like that, has a confidential source, and then comes up with information that is really detrimental, that could cause some harm to the country, And then what does that person do? Does protect his sources, or does he go to the authorities?
You know, that does happen every once in a while. I'm trying to think if I can remember anything on the national security side, but I can't think of anything off the top of my head. I do remember a couple of situations, though, where the reporter got information and the source wanted to be protected, and the first thing the reporter did, because there was obviously a threat to public safety, they went to the cops immediately. The most obvious one I can think of is the BTK killer, bind, torture, kill killer in Wichita. They had him for probably 15 to 20 years. He was sending them memos, and the newspaper didn't report on any of that. They knew they had the guy. He was a serial killer, and every single time they got one, they called the cops and turned it over. And eventually, when they did find the last piece of information, it was because it was turned over to the police. I mean, there are certain times, and I've spoken to other editors over the years, where that has been the situation, and then they do go. The other thing that they tend to do, let's say you get that information, you would go to the intelligence agency or the law enforcement agency. You'd want to get a comment from them, and you would want to know, say, hey, you know, we'll give you the information. We're just not going to tell you who gave it to us. That happens every once in a while that I'm aware of. I'm trying to think. Yeah, that actually happens quite often under the guise of getting the agency to comment for you. But they still will protect where they got it. They will turn it over, but protect the source.